Prayank, being the IT person on the panel, can you just tell, according to you, what is the right time to file patents for a startup? And should they be really considering protecting their IP before pitching to investors?
All right, excellent question. I'll answer the second question first. Should the startup be really filing patents before they are pitching to an investor? I would say before even sharing the idea with their friends, colleagues, or their wives or their girlfriends, what a startup company should do, or any company for that matter, or anybody who has an idea, what they should do is they should call their patent lawyer and file the idea or a patent for that idea, be it a provisional or complete, so that nobody can tomorrow claim saying that I knew this idea before you filed an application. In other words, before you disclose your idea to anybody, okay, you should file the patent application so that tomorrow you can
Sure.
claim the date of disclosure. And so that way you basically protect your rights, you protect your ideas before going it to the public. The reason why it's important is because patent will be allowed only and only when your idea is not present in the public domain. So if you disclose your idea to other folks, people might just Google it up. It will be available online, and people would be able to oppose you while you are seeking the protection from the government. Once you have a patent protection file before doing that, you don't have to fear anything. I mean, you can directly walk into the investor room and show your product, your prototype, talk about your idea in detail. You can even explain the how part of your idea which startups at early stage resist to while they have a discussion across in the investors. I mean, Travis and Scott would agree on this, that most of the investors are also reluctant to sign NDAs in most part of the countries. They would feel that if you are a startup is coming to an investor, okay, and it's in startup need the funding from the investor, then why should there be really an obligation to sign an NDA? So most of the folks also reject doing that. They don't take it in a positive spirit. And if you have a patent file, you don't have to worry about anything. You can just walk into the room, talk about the idea in detail, and get the $1 million check which was waiting anyways for you, right? So having patent protection before disclosing anything to anybody is the most advisable thing. That holds true not only just for startups but for professors, for students, for companies, small and medium. Before going out to disclose anything in online or offline, try filing the patent first, and then you can of course go ahead and disclose the ideas.
Wonderful. So, to all of our audience who are listening and who have not yet protected your IP, protect first and then go on to sharing your inventions. So, that's the key takeaway.